Hey everybody, John Skiba here. It's Thursday night. Welcome to the Consumer Warrior YouTube channel. Like I try to do each and every Thursday night. I wasn't here last week, so I'm sorry if I missed any of you. It's that time of year where I've got a daughter graduating from high school, and we've been out looking at colleges, and I was on the road, and it just wasn't going to work. So sorry for missing last week, but glad that all those who are here already this week. This is what we do each and every Thursday night. We talk about all things debt related. Again, my name is John Skiba. I'm an attorney in the state of Arizona. I help people with debt issues, consumer debt issues. Particularly, we look at bankruptcy and defending debt collection lawsuits, particularly those filed by credit card companies, junk debt buyers, debt collectors, that kind of thing. And so what I like to do each week is answer questions and just kind of make this a discussion. If you have a question, you can put those in the chat section, whether you're on YouTube or Facebook. I'll put it up on the screen and we'll talk about it. I have to give you my disclaimer because that's what we lawyers do best, is we disclaim things. My disclaimer is that while I am a licensed attorney in Arizona, I'm not licensed anywhere else. I can't give legal advice, and this shouldn't be considered legal advice because I'm not your attorney. This is just some guy talking on YouTube. So take that for what it's worth. If you do need an attorney to help you specifically if you're in Arizona, actually in the chat section, I put my scheduling link. You can click on that. You can set up an appointment to talk to me. People are surprised that it's always me who does the consultations. I actually will talk one-on-one. Even if you're not in Arizona, you can click on there, and there's some resources to get you in connection with someone who is in a different state, your particular state, to be able to help you out. So each and every week, too, I talk about the great people over at SoloSuit. They're one of our sponsors of this weekly live stream. SoloSuit is a company that uses technology to help people who've been sued by debt collectors to draft answers to lawsuits, to compel arbitration, even debt settlement. So I put a link there in this section. If they're great people, it helps support the channel. Go ahead and check them out as a resource to if you're looking for help in representing yourself through some of these debt collection type lawsuits. So there is let me see here. There's already a number of comments. There's a couple things on the channel that I wanted to address as far as some comments that were left there that I like to go back and take a look at, just because I can't always get to all the comments. But I thought some of them might be interesting. This one here has to do with debt collection and debt lawsuits, in particular process servers. So if you get sued by a debt collector, they actually have to come by your house and drop off the complaint in the summons. That's called service of process. That's where the whole "you got served" thing came from. At least I think I did. Maybe it's something that young people, anyways, you got served. If you've been served, they bring by the complaint, the summons, and they drop it off. This person said they got served with the summons of complaint at 9:10 p.m. at night. It says, do they have the right to come that late? I live in Las Vegas. Well, if you live in Las Vegas, that's a town that never sleeps. I went to UNLV. I know about this. So that's probably when things were just getting going. But in all seriousness, when it comes to process serving, they are excellent at coming at the most inconvenient of hours. And the reason is because they know if they come during the middle of the day, most people are at work or at school or something like that. So what I have seen is process servers often come by like Sunday mornings at 7 a.m., 8 a.m. They'll come by late at night, kind of like that. And what this person is referring to is that there are some restrictions on debt collectors as far as when they can contact you. There's a federal law called the Fair Debt Collection Practices Act, the FDCPA. And it has all these rules that says, hey, debt collectors, you can't call John before 8 a.m. or you can't call after 9 p.m. at night. And if they do, it's a violation. The one thing when it comes to the FDCPA does not apply to process servers. It only applies to debt collectors, which is weird in my book because these process servers get free reign. I can understand it a bit because it would make it very difficult for them to do their jobs if they could only come like during daylight hours. But the FDCPA does not apply to process servers. So unfortunately for our Las Vegas friend, that service counts and you're not going to have any specific recourse there. So, all right, let's see here. Let's jump into a few questions. Monterey MX was here bright and early. It says, if you want to track your bankruptcy to make sure your attorney filed the 121 plus declaration page. How would you go about that? Good question. So you can follow along with your bankruptcy case through what's called the PACER system, PACER. You know what? Maybe I can put a link in the show notes here or in the comments section. Let's see if I can do this. I'm doing this on the fly. We're doing this in real time here. So you do have to set up an account. And then once you set up the account, let's see if I can put this in the chat section. All right. One-man show here. So we're doing this all together. So, okay, I just put the link there. You can sign up through PACER. PACER is how with federal court and the bankruptcy courts are part of the federal system. You can follow along if you sign up for a PACER account. Not only that, you can look at the documents. You click on links. They do charge a fee, and I believe they even do for people who are involved in the case. It's kind of crazy. They charge you 10 cents each page of every document that you look at every time that you look at it. You can download it and store it. You get one free look, but after that, they charge you 10 cents a page, which is kind of crazy. The state court system in Arizona, there are fees, but not per page fees every time you want to look at it. But that's one way you can take a look at it, just to kind of follow along. Because you want to say the dismissed if not filed in 5 days really got your attention. There are a lot of strict deadlines when it comes to filing for bankruptcy. This is actually something we're kind of struggling with in my practice right now because there's so much information, so much documentation that has to be filed. And if you don't file it timely, you can get dismissed. What you're referencing, one of the first documents is you have to file a list of all your creditors within 5 days of filing your case. Otherwise, it'll be dismissed. Now, even if it's dismissed for something like that, it can be reinstated pretty quickly once you file the document. But, typically there's a 5-day deadline, then 14-day deadline. And there's all these deadlines that you have to work on. That's why being a lawyer is so stressful. It's just never ending deadlines. And if you miss those deadlines, there's big consequences. So, so that's one way. PACER is the way that you're going to be able to do it, to be able to take, if you want to follow along on it. Okay, let's see here. Travis Family Travels. Travis, how are you doing? Or Travis Family. I'm assuming that's probably your last name. Warning, when you settle a debt with collectors, make weekly calls to the clerk to ensure that the case is dismissed with prejudice. Don't trust the debt collector. They will park it in the court for years. It is always good. I think it's good advice to always follow up. One, if you're going to settle, and particularly if there's a lawsuit involved, but even if there's not a lawsuit involved, you need to get it in writing. Whether it's an email, a letter, get some kind of correspondence. Emails work. Believe it or not, those work. Those are binding upon the parties if they've gone back and forth. Most debt collectors, if you ask for a letter just memorializing the terms of your agreement, that works as well. But making sure that case gets dismissed, it might take them a while to get that paperwork filed. And so you should keep following up with the court, following up with them to make sure that that gets done. Most debt collection firms have relatively few attorneys and gigantic caseloads. And so things can slip through the cracks very easily. I see that happen all the time. And so it's something where, just to make sure to follow, to make sure you have that paperwork for your file, just in case years from now something comes up and you need to be able to prove that it got settled. So, all right. Red Panda Daddy says, would it be better to do bankruptcy before or after vacation? Tickets have been paid for months now. Only thing not paid is the hotel. Tickets are non-refundable. This is actually a really good question. And it's something in Arizona where I practice, we run into not a lot, but periodically. Here's the issue. You file Chapter 7 bankruptcy. You have pre-purchased flights or a pre-purchased hotel. You put a deposit down on it. There are trustees in Arizona that will try to go after the value of those tickets or try to recover monies that you've paid, because it's essentially, it's an asset that you purchased out there that hasn't been used yet. So, I would recommend talking to an attorney if you're going to file for bankruptcy as far as the timing, because timing is a big deal. That's really where the lawyers are super helpful, is in making sure that you time it appropriately. If you've already purchased that, just so that you don't want it to be an issue, I would likely tell a client to wait and file their bankruptcy after they go on the vacation. Same thing, just so that there's no issues. The thing you're going to have to be careful of is a lot of credit card usage right prior to filing bankruptcy. If you rack up a bunch of credit card debt within the 90 days filing, prior to filing, the credit card companies can actually object to those specific charges from going away. So that's something you got to be careful with. So, all right, let's see here. JC Bradley 11 says, after filing my arbitration case, Midland emailed me with a settlement offer. Lawsuit has been put on hold by the judge. Is there anything I need to know or do before I accept their settlement offer? This is a common thing. If you file a motion to compel arbitration where you're saying, Judge, I don't want to deal with this in the judicial system, let's just take this to private arbitration. The court grants that. Midland and their attorneys, they do not want to go there in most cases. And so they come to you with an offer. So you can either accept their offer, you can submit a counter offer, whatever it is. It kind of goes back to what I talked to at the very beginning. If you're going to settle, you need to get it in writing. Even if, like I said, they've emailed you. If they email you an offer, if they're saying, hey, JC Bradley 11, we will settle this thing for whatever, $1,500, and you got to pay it in 30 days. If you just email back, I accept, boom, you got a settlement right there. So once you pay the settlement, and they usually wait for the payment to clear, then you need to dismiss the arbitration. And you can reach out to, if you've done it through AAA, or even if you haven't filed it yet, you don't have to do anything with arbitration. But then the parties, and particularly the debt collector's attorney, will file what's called a notice of settlement with the court to let the court know the matter's been resolved, and then the court will dismiss the matter with prejudice. So make sure you just get everything in writing, and you'll be good to go. A lot of the court stuff, particularly if arbitration has not been filed yet, if the court case is still pending, you said it's just been put on hold, it still needs to be dismissed. And the notice of settlement that the creditor's attorney will file, that puts the court on notice that, hey, we got this taken care of, we don't need you anymore, and then they'll dismiss the matter pretty quickly. So let's see here. Christopher says, I have a pretrial conference scheduled in New Hampshire in August of 2024. I'm being sued by a debt collector, Portfolio Recovery Associates. I do not have an attorney, as wondering if you should get an attorney. Well, I can tell you that, you're asking an attorney that question. Obviously, I think you're going to do better with an attorney. I recognize there are cases, and the reason why I do this whole YouTube channel, because I understand there's often situations where people can't afford an attorney, or it doesn't make sense. If you're getting sued for $1,000, it's not going to make sense to contact me and try to hire me. It's going to cost you more in attorney's fees than it is to get it resolved. If you're getting sued for $20,000, $30,000, $40,000, $50,000, $100,000, then it starts to make a lot more sense, and there's a lot more on the line. So, you can check out some of the videos I have here. There are some tools like Solo Suit I talked about. I also have my Consumer Warrior University that helps pro se litigants. It may be worth, I think it is worth your time to try to find an attorney in New Hampshire and just at least talk to them and kind of get their take on the case. A lot of it depends on how much you're being sued for, how much exposure, how much risk there is there. Portfolio Recovery Associates, they're a junk debt buyer. They're defenses to those cases. But having an attorney, that there's going to be additional costs. There's just no getting way around that. I generally think you're going to get a better result just because, just like everybody else does their job all day long. And, I do my job all day long. The attorneys do their job all day long. You know what you're doing and how to navigate the courts. So, So if you're being sued for $2,500, my guess is you're probably not going to get an attorney who's going to be willing to take the case for less than about $1,500. So I think that those types of cases are decent for you to kind of get yourself up to speed. If at a minimum, file an answer with the court, whether it's through, you can draft your own. There's Solo Suit. There's my Consumer Warrior University courses. They can help you out, get that filed so that you're not at risk of any kind of default. And then look at some of the other resources. And I have about 800 videos, I think, on this channel right now. A lot of them just how people can represent themselves and maybe some resources that you can reach out to get that squared away. So, all right, let's see. JC Bradley coming back and saying, Midland offered to let me make a payment plan or a lump sum settlement. If I make payments, will they dismiss the lawsuit with prejudice? Yes. So here's how it works. It depends on how many payments we're talking about. If it's something where the creditor is like, okay, well, I'll allow you to make $100 a month for the next 36 months to get this thing paid off, they're usually going to require something called a stipulated judgment. Stipulated judgment means you're going to sign off on a judgment for the full balance, but there's going to be some terms in there that say, J.C. Bradley is going to make payments of $100 a month. He's going to pay, 80% of the total balance. And as long as he's making those payments, we agree we're not going to do anything to try to collect. We're not going to bother him. We're not going to try to garnish him or lien his home or anything like that. But if JC doesn't make his payments, then at that point, we get the judgment in full. So it's kind of their security in the event that you don't follow through. They have that. So if you can do a lump sum, you're generally going to get a better deal. Particularly, someone like Midland, I think a good deal for a lump sum is like 25 to 40% of the amount that they're suing you for. If you're going to do a long-term payment plan, they're going to require something probably closer to the full balance. So that's, just a couple of things to consider. And it's usually not until you actually make the final payment that they're going to dismiss. So that's where you got to be careful. The one thing I always push for, if you're doing any type of long-term payment plan, is to make sure you put in a grace period on your payments. If the payment's due on the first of every month, you need to ask them for a 5-day grace period before they default you. The reason is because what if the first is on a Saturday or a Sunday and you can't make the payment? Most big debt collection firms you can pay online now, so it doesn't become a big deal. But what if your payday is delayed or something like that? So I always ask for a 5-day grace period before there's any type of default, and then you should be fine. All right, the other side, 54 says, can you explain how a 1099-C works? So yes, so the 1099-C is the little thing that, little grenade they throw at you after you think you've got this thing finally resolved. But what this is there may be tax liability. You may have tax liability for settling a debt. And how it works is any amounts that a creditor forgives over $600, the law requires them to issue you a 1099-C. And 1099-C, it's a document. It comes in the mail. Most creditors kick these out in January of each year for the year prior. And what you'll see on there is that you have to treat any amounts over $600 that they forgave as income on your taxes that you file that year. And so the 1099-C, so for example, if you have a $10,000 credit card and they agree to take $3,000 for it, you may get a 1099-C for about $7,000. Now, I always say it's better to pay taxes on $7,000 than it is to pay $7,000. And there are, if you particularly if it's a larger amount, I would recommend if it's a larger amount that you've settled, and especially if you've got a good deal. If you have a $20,000 credit card and they took $5,000 for it, you get a $15,000 1099-C. It's a good idea to have an accountant or a CPA help you with your taxes, because there are some exceptions to this rule. If you are technically insolvent, if your debts outweigh your assets, then you may not have any liability at all. And so that kind of delves into accounting, but I recommend you do that because you may not have to do it. And for most people, it's not going to be a giant thing, but it could be. And it could be something where all of a sudden, if it's a big settlement, it's pushing you into a different bracket or something like that, and could have some real tax consequences. Now, it's important to know there is a difference between debts that are forgiven by a creditor as part of debt settlement and debts that are discharged in bankruptcy. There is no tax liability for debts that are legally discharged in a Chapter 7 or a Chapter 13 bankruptcy. So I know I've had bankruptcy clients who get really nervous saying, I thought I'm going to get all this tax liability after I get my bankruptcy discharge. You're not going to get that. That only applies in debt settlement. And that's where you're going to have to be careful with it, with the 1099-C. But like I said, and they also, here's another little nugget. They have like 3 years to provide you the 1099-C. So I've seen clients who will settle a debt, and then it's 3 years down the road, they get their 1099-C, just to make things, more complicated. And I have seen situations, I've actually seen it a lot where the creditor never sends one. They're required to. It's not on you to, be knocking on their door. They're required to issue it, but I have seen it where they just don't do it. So, all right, let's see here. This person says, I owe $100,000 on taxes that are over 8 years old. Can I safely file for Chapter 13 to dismiss that tax liability? So a lot of people are surprised to learn in bankruptcy, taxes sometimes can go away. There's some specific rules, though, that govern when taxes can be eliminated. Now, and we can talk about Chapter 7 and Chapter 13, but regardless, if the tax debt is at least, I'm going to give you the three different rules. The taxes have to be at least 3 years old, okay? And you have to, that's rule number one. The tax debt has to be at least 3 years old. You had to have filed a tax return for the year that the tax is owed, and the tax cannot have been assessed to you anytime in the last 240 days. So we can go through kind of what that means. The first one is that it has to be at least 3 years old. Now, when you're calculating that, you're probably like, okay, that one's pretty easy. But how they calculate it, it's 3 years from the date when the tax was due. So, for example, I'm recording this in 2024. So let's say you filed your taxes, your 2023 tax returns, when they were due on April 15th, 2024. That's when the 3 years starts ticking going forward. So if you had tax debt from 2023 that was assessed to you when you filed your tax returns in April of 2024, you would have to wait 3 years from April 2024. So that's going to push you into April of 2027 to get rid of the tax debt from 2023. Clear as mud. So that's, and it's also, you got to be very careful if you have filed for extensions. If you got an extension to October or something like that, it's 3 years from when the tax debt was due. That's the 3 year rule. As long as it's been at least 3 years. And next, you have to have filed a tax return for that year. It doesn't have to be, filed during that year. So if you're late, if you're behind on them, but you have to actually have filed the return for that year. And then the last rule, it cannot, the tax debt cannot have been assessed at any time in the 240 days prior to the filing of your bankruptcy. So if you just filed the return, it's more than 3 years old, but then they just barely sent it over to you, you're going to have to wait at least the 240 days. Or even if they did like an audit or something like that, then you're going to have to wait the 240 days. So something to be aware of and be careful of. All right. Got Jacob here saying, should I get a lawyer? Do I have to appear in court or represent myself? I kind of touched on that. You're asking a lawyer that question. So you're getting a completely 100% biased. I think a lawyer is going to help you. It often helps, particularly in court. Now, it kind of depends on which court you're in. If you're in court, it could be, if it's like a small claims court, like Arizona has like a justice court that deals with cases under $10,000, Superior Court over $10,000. And then within the justice court, they have a small claims division. Now, small claims division, like in Arizona, attorneys are not allowed. And so if it's something like that, it's usually a much more informal proceeding. Like at Arizona's justice courts, though, they're a little more formal, and the Superior Court, they're a lot more formal. Or if you're, for some reason, in federal district court, it's like crazy formal. And so attorney's going to help you, particularly, Jacob says that it's district court. So if it's in district court, just above small claims, it will help you, particularly if there's a trial. I've had clients, I do sometimes what's called limited scope, where the client has done the answer and they've kind of done all of the initial paperwork, but there's a trial coming up or oral argument, something like that, and they'll bring me in to do that. Trial work is something, even new attorneys, it makes them super nervous because it's not something they're used to. It's definitely a skill. It's definitely something that there's a lot of procedure. There's kind of the unwritten order of things as well that kind of makes things a little bit more difficult. But that being said, can you do it yourself? Yes. And, if you're a regular here on the channel, you're going to see comments of people who come here every Thursday night who win their cases doing it themselves. So I always think it's worth talking to an attorney, doing a consult with someone locally, kind of getting their take on it and seeing if they can help you out. So, all right. A couple other questions. This one was from the what do you call it? From the comments. Said, I've always been told that there's no debtor's prison in the United States. If you're sued for a debt, could you end up getting arrested and going to jail? There are no debtor's prisons. They were outlawed by the federal government, I believe, in 1833. So it's kind of a thing that's hanging on. It's been, we're coming up on 200 years. And most states had outlawed debtor's prisons by about 1840. So it's been a long time, but we still kind of have that fear that we're all going to jail, if we can't pay our bills. Now, let me give you some exceptions. There are a couple exceptions. A lot of them we understand. Taxes, which we were just talking about. If you're intentionally not paying your taxes, that can be considered criminal. You could go to jail over that. Child support, if you're not paying your child support, it's possible there are criminal statutes that are there, and you could end up going to jail for that. Those two things aside, the most common thing where I see people get themselves in trouble is when they find themselves in contempt of a court order that's associated with a debt collection case. Where I see that the most is if a judgment gets entered. So you go through the whole trial, summary judgment, default judgment, whatever it is. Most jurisdictions allow the creditor to do post judgment discovery. And so they will set often, at least what's in Arizona, is called a judgment debtor's exam. This is where the court requires you to come in and essentially spill your guts. It's all your financials, tax returns, bank statements, all your assets. You have to disclose everything so that the creditor can get information to try to collect on the judgment. That's typically done. The order to appear at that judgment debtor's exam is a court order. In Arizona, if you don't appear, they can hold you in contempt and the judge can issue a civil arrest warrant. And you may be asking, do they really do that? They 100% do that. So I always tell clients, hey, look, the 100%, if you disobey that order to show up at the judgment debtor's exam, and the civil arrest warrant in Arizona, it's not an arrest warrant where they're, SWAT's coming and knocking down your door or anything like that. But if you get pulled over for speeding, if you get pulled over for, driving in the HOV lane, whatever, they take you into custody, they bring you to the court, they call the attorneys, and then they have you provide that information. So that's the only thing you got to be careful of is if there's something like that, a court order, you got to follow through on it. Otherwise, it could cause you some issues there. So, all right. You know what? That is about a half an hour. I think that's good for this Thursday. I think we'll end it there, but I appreciate everybody checking in. Again, there's links in there on my at the top of the thing on YouTube and on Facebook for our great sponsor, Solo Suit. Well, got to take down all my other banners here. Clearly, I'm doing this on my own. Clearly, I'm doing this on my own. So check those out. Click over there, Solo Suit. They do a great job to help you out. And like I said, if you're new here, go check out the other videos, subscribe to the channel. We just passed 59,000 subscribers, which is awesome. When I started this years ago, I didn't ever think we'd have that many people, checking in. But go ahead and do that. And if I can be of help with a consultation, my calendaring, scheduling link is right there. Check that out. I'd be happy to talk to you and see how I could help you out. With that being said,